system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
Welcome everybody. It is Justice is a Process here. I'm Steve. I'm Justice is a Process. I'm the guy behind the camera that you don't see, although you should see more, and you will see more hopefully in the near future. But normally I will come in between breaks and things and come talk to you guys while we're watching these cases together. But as I've explained, I've had a lot of family things going on that's kept me away from the studio and unable to pop in. But this case is so important, I think it deserves a segment. So that's what I'm doing. I want to talk to you guys about why Daisy Lynch should have been found not guilty. Now, I'm going to tell you, I prepared this presentation in preparation for coming on, hopefully during jury deliberation, spicing it up a bit and sharing my opinion on what I thought the jury would come back with. Now, the verdict's already been delivered. If you haven't seen the verdict yet, go back and check it out. I don't think as of right at this moment, I have not released the verdict video yet, but you can go back to the live for day 6 and you can see the verdict for yourself. I'm not going to spoil it. Well, it might get spoiled if you're watching this show, but, I guess I'll spoil it. I have to spoil it. She was found guilty. All right. She was found guilty. I disagree with the verdict. I know there was a group of people in chat that, and throughout this trial who have believed she's guilty. And I respect that. I respect the juror's verdict. Even though I disagree with the verdict, I respect it. But I'm going to go over what I think is the compelling evidence that supports that she should have been found not guilty in this case. And to me, I think this is just the way jurors tend to look at things. And sometimes they miss the law or they miss the nuances of the law. You all let me know in the comment section whether or not you're swayed by anything that you learned tonight. And we're going to go through it. The report that you're going to see is in the Justice Watcher folder. It's under presentation. So if you are a Justice Watcher, you can get a copy of this report, just like you can have just like you should have copies of all the reports for this entire case, which should give you a pretty good idea of where I stand on this case. They are HTML documents now, meaning what you need to do is you can open them. They're not going to be formatted as nicely if you open them as a Google Doc. But if you download the document into your browser, it will format into a very nice document that's got interactive links, interactive hyperlinks, and you can go back and watch the moments. I'm not going to pull up every bit of testimony hyperlinked in this report, but you can go in and do so and watch it and watch it along with the analysis that I present in this report on Daisy link. Now, I'm going to be presenting the report here. I'm going to be scrolling through it. I will also provide a link in the description of this video. Now, you may be saying, hey, wait a minute, you're giving this away. No, I do. I give away all my reports, okay? Because I believe these are important enough documents and important enough perspectives. I want the entire community to hear it. Now, what I do is if you are a member, you get access to a folder that organizes all of these documents in a very nice, completely easy to read, start to finish. As they come in, you order them by the date that they entered, and you will have the entire record without having to go through all the videos, without having to go download them yourself. You can literally go into this folder, download the folder, you have access to it, and have access to it for the entire case. They're hyperlinked. They take you to the places in the videos that I'm releasing. You can watch and have a roadmap to the entire case, exactly telling you what my perspective is, and coming from the guy right above me, my dad, Stephen M. Askins, the first, one of the greatest legal minds you've probably never heard of yet, but you will be hearing more about him in the near future as we cover his career. But you can go through and see all of this. And when we get to a point like this where I'm covering a verdict, you will not be surprised or shouldn't be surprised if you've covered my coverage of the case. I also provide them on, if you go to x.com, that's at JIAP, J.I.A.P. And you go to X. You can also find the link here on the website. You will find all of my justice reports over on Twitter. Now, they're not in a folder, they're not easily organized. The only way you get a nice organized database of all that information is if you are a Justice Watcher member, and I put that up in the community, in the member community post, and it's all right there for you. So anyways, just want to go over that so that you know where to find these documents and that you can go along, because I want this to be an interactive experience. I want you to be interacting with the polls. Don't want you to just vote. I want you to comment, and I am going to begin trying. I'm implementing some things here to try to be able to interact better with the comments and respond faster to comments. And I'm going to be trying to do more videos and lives where I interact with your comments and talk about them and bring them to the community, especially if I see one that I think needs to be displayed. And if you're a member, I'm going to be putting members' comments up first. So it's a great way to get your comment recognized. And if you super chat at me or super posted or, supered your comment in, that's going to be up there too as well. So it's a great way to be bumping to the front of the line and getting my attention, because as YouTube just told me, the lifespan of this channel, we've had almost 500,000 comments about cases. So it's a great accomplishment for the channel as we're nearing 80,000 subscribers. So that is a hats off to you guys. I wanted to touch on all those things. Hopefully I haven't lost half of the people that tune into this video. But if always, whenever I put up a video, I put up timestamps. So if you don't want to see all the introductions whenever I'm coming in here and talking to the community, just click to the first timestamp. Don't leave the video, click to it and get into the business. Now, let's get into the business we're all here for. This is not going to be some 3-hour event like I used to do back at the beginning of this channel. This is going to be, I hope to keep this within a relatively reasonable spectrum. Bear with me as we're jumping between things, but we're going to jump in here. When I record these things, the kids might come in the room. You might hear background noise. Bear with me. I've gotten complaints about that. Listen, this is not court TV. This is not Law and Crime. This is not a network. This is a one-man operation who's trying to come out and bring the justice system to you, to your living room, give you perspective, and continue on the mission of the man above me who sits with me every single time I broadcast. And he's right up there now. And you may wonder, why is he there? Because I want him there. So if you think it's getting in the way, I apologize, but he's going to be there because he deserves to be there, because without him, this channel doesn't exist. You're going to learn more about him. Go to my About section of the channel, learn more about him so far, and there will be more coming, because he's the man that made this possible. And we're going to continue to recognize injustice as a process is what he said, not me. He came up with that, although others did, but that was his explanation for how he defended people like Daisy Link, like many of the people we've covered. How can you how can you represent them? And he said, because everybody deserves to have a fair justice process. Justice is a process, not an outcome. I'm not interested in getting them off. I'm just simply interested in helping to make sure that they are afforded every right that they're entitled to while they move through the justice system. And that was his explanation, and it resonated with me. And it was how I explained my dad, as people would ask me and say, how does your dad represent? How can you do that? How can you support your dad? And I'd say, because justice is a process. It's not an outcome. It's not about what the outcome is. It's about a fair process. And you're going to see as we cover this, that process, and I covered several aspects of this, from missing evidence to late witnesses. That process was not fair. The prosecution did not play fair in this case. There were several points where the judge got really, really upset about it. And that, of course, the process continues for Daisy Link. That will all be reviewed by the appellate level courts, and they will decide how much of an impact and whether it made an impact that either overturns her decision or sends it back down. Those will all be things for another day. We're going to highlight it here in this report. But I really, truly do believe that if this jury would have been looking at things by the law and not emotion, that they would have come up with a different verdict. But anyways, let's break it down here, see what you guys agree. See what you guys think as we walk through this presentation. Download the presentation now while I'm going here. Go right into the description, hit the download button, have it up in front of you. You can walk through it with me as I'm walking through it. Give me a moment here. All right, so here we go, guys. So the first, as you can see, it's pretty self-explanatory title. Actually, hold on a second here. We're going to go with get a closer up view here. There we go. So here it is. This is the document here. So the case for self-defense under Florida law, and it looks like we're cutting off the top of the document, but that's unfortunately all it says is why Daisy Link should be found not guilty. Let me give a far away view. After that, it won't matter because we're scrolling. So why Daisy Lynch should be found not guilty, the case for self-defense under Florida law. So first we got to get to know the law that the jury was evaluating this case under. And it's pretty simple. It says the legal standard, what the state must prove. So Florida self-defense law, look it up for yourself, 776.012. Under Florida law, a person is justified in using deadly force if they reasonably believe such force is necessary to prevent imminent death or great bodily harm to themselves or another. Once self-defense evidence is introduced, the burden shifts entirely to the state to prove beyond a reasonable doubt that the defendant did not act in a lawful self-defense. This is a complete burden shift, meaning at the beginning of the case, the defense merely needs to present it as a possibility. Once the judge acknowledges that that's happened, and they did in this case, the burden shifts completely over to the state. And now they are held to the standard of proving beyond a reasonable doubt that she did not act in self-defense. The state must prove that all reasonable doubt is gone, and if any exists, if there's even one scintilla of doubt at the moment that that jury is deliberating and the verdict is voted upon, the jury should vote not guilty, and they must acquit. Now, let's get into what does a reasonable belief mean. The law doesn't require, and this is important, the law does not require that Daisy Link actually faced imminent death or great bodily harm. It requires that she reasonably believe that she faced that threat. And this is an important thing to understand. We get into this because it is this basis you must evaluate everything we're going to talk about. And that this jury, I don't believe, you're not going to convince me when the deliberation goes less than 2 hours in a case that lasted 5 days. Okay. It lasted 5 business days of evidence. And that's what I think offends me greatly, right? They say for every day of business that a jury conducts, a reasonable deliberation would be 1 hour per 8-hour day or per court day. 5 hours. This jury came back with a verdict, by my count, in less than 2 hours, meaning it might even been less than that. That is disturbing to me. That is not okay. But it is what it is. That just tells me that this jury was extremely biased towards Daisy Link. But in a case like this, with the victim who he was and what he was, it was shocking to me to see that happen. But that's what happened. So the law doesn't require that Daisy Link actually faced imminent death or great bodily harm. So he did not need to be threatening her. It just required that she reasonably believed that she faced that threat. And that's what the defense attorney was trying to understand. Now, I have not aired the closing arguments. They will be airing later tonight and into tomorrow. Okay, but I thought the defense attorney did a great job in closing this case out. I thought so. It's my opinion. I thought he did a great job explaining this. But the jury must place themselves in her shoes at the moment. And this is where juries struggle, I think, with this concept. And the concept is that they have to put themselves in her shoes, not their own evaluation, but they have to literally take the time. And this is why it tells me that when a jury comes back in a case like this so quickly, there's no way you can tell me that they sat back there and discussed this aspect and said, hey, let's put ourselves in the shoes of Daisy Link. Let's go over everything like what we're about to go over and break down. Let's go over all of that. Let's put ourselves viewing the world from her perspective, her life experience, and what's happening. That's what it requires. And I don't believe that happened here. Knowing what she knew about Pedro Jimenez's violent history, his behavior that night, his cocaine-fueled state, and the immediate circumstances. Now, there's also a stand your ground component. Now, I understand the judge already ruled stand your ground, but the jury could still consider those components when looking at it. Florida law explicitly states that Link had no duty to retreat. She was in her own home, on her property. She didn't have to run away. There's a court order in place that says he's not allowed to be there. She didn't have to hide. She didn't have to leave. She didn't have to let Pedro leave and come back later. If she reasonably believed that deadly force was necessary and the jury finds out to be such, she was justified in using it. She was justified in using it. Now, the defense evidence. What did the defense show? So let's get into this. What they showed, and we will watch a few clips together of some of these things. We're not going to watch all of them, although I've compiled them. If you, like I said, grab this report, grab it, read it, get with it, and then come back, come into these comments, and let me know what you think. If you're a member, you're going to get priority as far as me to see the comments and read the comments. If you super chat me or give me a super, I'll also definitely see it. And then, of course, if you leave a regular comment, you're going to see it. I respond to all comments. But I want you to come tell me what you think about what we're talking about here. So let's talk about the first thing, pattern of violence in Pedro's history. So let's look at this. What is the pattern of violence in Pedro Jimenez's history? So 5 days before, and this perhaps to me is the most important part. 5 days before, there's an incident that mirrors this situation that she was facing almost exactly. It's the pretext to understanding her mindset, or should have been, for this jury. Because what do we see happen? PJ, her son, testifies. Yesterday, he testified that Pedro Jimenez attacked Daisy with a gun 5 days earlier. It was not a simple domestic dispute. According to the child who witnessed it, he arrives at Daisy's home uninvited after she changed the locks. He accuses her of cheating. He pulls a gun out of his backpack. He fires the gun at her. When the shot misses, he begins pistol whipping her with the weapon. He hits her multiple times in the head with the gun. Her cousin David has to kick the gun away from him. Pedro retrieves the gun and then continues the attack. She's hospitalized after this, guys. And again, as I said, this is critical context because this is understanding that Daisy Link had personal recent traumatic experience with this guy, right? That he showed her he was willing to use a firearm to potentially kill her or injure her. And then 5 days later, he shows up. He's exhibiting similar behavior, similar erratic behavior, threatening behavior, and leading her to reasonably believe that there was a deadly threat possible. Not, and that it wasn't just reasonable. It was inescapable, in my opinion. It was inescapable that that's where this was heading with him that night. And then on top of that, we add in that he's high on cocaine. His state of mind at the time. The medical examiner testifies that Pedro Jimenez had 274 milligrams of cocaine in his system. That is a potentially lethal level. Although if you listen to the new Charlie Sheen Netflix documentary, you see there are some people can take a lot. And he was knocking down according to Charlie Sheen, he was legitimately knocking down 7-gram rocks, and he was partying for days. Pedro Jimenez seems to be one of those human beings that could do this. But he's high on 274 milligrams of cocaine. He's got an alcohol BAC level of 0.108. He's high on marijuana. He's severely intoxicated. He's chemically altered. We know, as per the medical examiner, what does cocaine do to somebody? It increases their aggression levels, it impairs their judgment, impulse control, heightens strength, reduces pain sensitivity, creates paranoia and unpredictability, eliminates rational thinking. The jury had to consider in this instance that would a reasonable person who's just been pistol whipped by this man 5 days earlier, would it be unreasonable that she would believe that he's now highly intoxicated? He's now at the house. He's refusing to leave. He's basically exhibiting the same behavior to put her in the hospital. And she gets a hold of the gun first. And he's charging towards her. He's charging towards the house. He's acting erratic. He's acting crazy. He's acting insane. And she fires a shot. She doesn't shoot him in the head. She doesn't shoot him in the back. She shoots him. The bullet ends up somehow ricocheting around and hits an artery. And we're going to charge her with second degree. That she had a depraved mind when she did that. That this woman who's been through all of these things, her son testified, she testified, it's irrefuted evidence. The state wasn't able to refute that. The state stood up in their closing argument and said, he is a bad guy. Yet they want to lock her up and they can sleep at night, locking her up for shooting a man who would have killed her a week before. That's the system we have down in Florida. That's the system we have in America. That's the people that sat in chat and said, I want to lock that person up. Now, the judge has discretion on her. The judge has discretion on how she sentences her. And that's why this is going to be a long sentencing process. You've already heard 8 weeks for the PSI. And I'm sorry. I'm going to calm down. But to me, prosecutors have a decision on what they charge people with. But the prosecutors, you could sit here and say that this is an individual under all these circumstances, the entire background, and looking at what she did that night and the way this went down, and they're going to charge her the way they did. They're going to prosecute her. They're going to sleep at night saying, we just took her off the street because she defended herself against an individual who was absolutely on the road to killing her. She had a protective order in place. And yes, she did things. Yes, she brought the man back. What I don't understand is why the defense, and again, I did not dig into the pretrial documents. I'm sure it was something that was addressed. But if there's ever a case that screamed for context or understanding the mind of a woman who's going through this, this is a case that demonstrates that and helps the jury to understand that you cannot judge this in the light of a rational human being, because there's nothing rational about going through all of that stuff. Things are done that are unexplainable, because they're explainable because they're under the influence of an individual that they keep going back to, and that they keep doing things, and they keep saying, you got to get away from them. How many friends and family members say it? They go back and they go back and they go back. And that is exactly what was happening here. And then she finally had to take action to save her life, save her kid's life, prevent another pistol whipping, prevent it this time from turning into a deadly incident. And the police go, okay, we don't like the way you acted. You lied to us. You weren't honest with us. You didn't trust us. So we're going to charge you with second degree. Disgusting. Terrible. So what else do we have here? We have the friend's testimony. And again, click these links. I'm not clicking them right now. We'll watch some of them. We're going to watch certain ones, but we're not going to watch all of them, because if we did, we'd be here for like 3, 4, 5 hours, right? But I'm providing this report. It's in there. It's in the description here. You can go on. You can watch. You can download this if you're a member. You have it in your members toolkit. Pedro's friend testifies that Jimenez, that he was at the house. And this is all also as well in our coverage that we have done throughout all of the it's in the podcast. Playlist. All of these videos are featured there in the podcast playlist. So, you can find them all there. But, so make sure you check them out. And you can watch all this testimony and all the coverage of this case. I am very sorry, first of all, because this is a very poor quality presentation from the court system, but we are watching live courts. Okay. So I always laugh when I see people getting upset because they're sitting on YouTube watching court and they're complaining because they don't have studio level microphones in the courtrooms. They don't have studio level cameras. This is court. This is real life. This is the true IRL, right? They talk about IRL streams. We're IRL streaming here. We're showing you what goes on inside our courtrooms. And yes, you're not getting a soundstage for that, okay? That's not how it works. But anyways, so Pedro's friend testifies to the jury. This is evidence before the jury. This is a state witness. He testifies that Jimenez was at his house consuming cocaine, marijuana, and alcohol before Daisy arrived to pick him up. He admits that Pedro went in the kitchen. He admits that when Daisy arrived, she went into the kitchen and found him. He admits that he doesn't know what Pedro was doing in the kitchen or how much he was consuming, but that he was there where all the goodies were and the candy was. This supports the defense's opening statement that Pedro is out of control. He's unhinged. He's getting high. This is not speculation. This is not just like, oh, she's saying it. No, this is coming from a friend who says, yes, He had access to this. He was using drugs. He was getting high. Of course, we also have the medical examiner who also confirmed that for us. Now, let's look at the next aspect. Let's move to the night of the shooting. Now we're at the night of the shooting. What do we see? Daisy's mother shows up, right? Daisy's mother testifies before this jury, and she was attacked by these prosecutors, just absolutely inhumanely attacked by these prosecutors. It's like nothing I've ever seen. I put a couple of videos up, put a couple of clips up. I thought it was despicable the way they treated her. Some of you might not agree with that because a lot of you don't care how victims, or not really, she's a victim in this as well. Her daughter's being lost in this, but they don't care how they're treated. But in my opinion, she was treated very poorly by the prosecutors. She was accused of watching Law and Crime without what I thought was any strong basis. She was given this transcript by Tomas, Attorney Tomas, and she's sitting there being yelled at by the prosecutors. The judge did take up for her and said, listen, stop this and stop addressing these things and stop making these claims in front of a witness. I'm glad the judge stepped up there and did what she did. But anyways, getting down to what the mother brought to the table. She testifies that after seeing photos of Daisy's injuries and from the pistol whipping, she was so concerned that she ends up coming from Texas. She flew from Texas, comes to Florida, and on the night of the shooting, she was there. So she actually confirmed and was and presented evidence to this jury that he was entering the home repeatedly despite being told to leave. He was engaging in multiple physical altercations with Daisy. He's refusing to leave the property when asked. He's exhibiting erratic behavior, aggressive behavior, consistent with cocaine intoxication. She's the last person that sees him alive, besides Daisy, about 30 minutes before the shooting. And she is corroborating what Daisy's saying his behavior was that night, what others have said his behavior was that night, like his friend, corroborating that he's out of control again and that they're heading towards something very, very, very bad. Okay. Very, very, very bad. So now the ring camera, right? Audio. What does it actually show? Well, the prosecution wants us to believe that the ring camera audio proves that Daisy was calm and calculating. But if you listen to it, if you take the time to listen to it, the defense revealed that the audio appeared to show that Jimenez is screaming, I want to die, before the fatal shot. He's actually saying, that's telling you how crazy he is. And it's context to prove that, look, this guy is completely unhinged. And when he's saying, I want to die, I don't care, shoot me, do whatever you want to do. Like, I don't care. Like, if you don't shoot me, I'm willing to die tonight. Are you? Like, if you don't use that gun on me, I'm going to use it on you, essentially, in so many words. We already know this. We don't have to say she's making a leap. He did it 5 days before. And he's basically calling her out, saying, I don't care if I die. I don't care. I will come get that gun out of your hand and I will, do what I need to do. Detective admits on cross-examination now, as he's, the detective that's listening to this when this was presented to the court, he says he could only hear the word die and they couldn't hear anything else. But the jury could hear this evidence. And what they can hear is that he's a man that's out of control. He's right. Now, I would play this, and I have it linked up. But as with all of the audio and all of the video in this case, it was not very strong. It was not very good. But you can go back and play it for yourself. And you can derive what you want from this. Now, this is a huge, and this becomes kind of the basis that the state is trying to use, was saying that her behavior following the shooting, that she was essentially, this is where they're coming from and saying, well, if she was someone who just shot self-defense, she would have never done the things that were done, that she wasn't genuine. However, if you go back, and we're going to watch this, and we're going to go back to this testimony. Sergeant Trayvon Nicholson testifies that when he arrives, Daisy's standing over Pedro screaming, what happened? And that from his perspective, he believes she appeared genuinely confused and in shock. He testified that she's waving officers down. She's rendering aid to Pedro. She's screaming frantically. She's helping officers locate the victim. That he did not believe that this is not the behavior of someone who just calmly executes this man. This is a behavior of shock, trauma after a life or death confrontation. We'll go through the body camera footage is played by the prosecution, and it shows officers performing CPR as Pedro is passing away. Daisy's frantically screaming. And it's evidence that when you look at this, the state's trying to say that she was staging this because they're basing it on the previous camera on previous audio where she's talking after the fact and she appears not to be in this frantic state. Um, and she's saying, "Oh, it's you know, she's making this up." Um, that there's a huge difference between what the body camera footage shows and then what the ring camera footage shows, which is before she calls 911 and as things are progressing right after the shooting. However, what I would say to you is that I think what we're seeing, and this is what I think is a better recitation of this, and this is just the way it is when people who are inexperienced with the law, they don't understand how to act or how to react. But for me, what I saw, what I heard as I'm going through this, and again, I've been through this testimony and videos multiple times as I'm editing these videos up and presenting them and preparing my reports. What I'm seeing here is more of this happens. She fires the gun, he gets shot, he goes down. And at first, it's like, I don't think I hit a major artery. Like, I don't think I did that. Do you want to go to the hospital? Do you want me to call 911? Do you want me to take you into the hospital? Do you want me to, hold on, buddy, I'm filming. Do you want me to, go to the hospital? Do you want me to take you in? And then it starts to become clear that this is a pretty serious situation. So now what happens? Oh, now it's becoming, a scenario where she starts to see as this is progressing, she can see that he's in trouble. He's losing a lot of blood and he's actually dying. I see this more of a progression of literally realizing the severity of the situation. And she realizes that this is actually a really serious situation, that this is something that really is much more serious than what she anticipated. That's how I see this. Okay. That's how I see the evolution of this. And this is not, she made all these comments. The one thing I will say is I feel like Attorney Tomas did not necessarily tell the story in his closing quite as well as I thought it should have been told by him to really help them get inside the Daisy Link mindset and say, hey, listen, how can you explain this behavior besides just say, okay, it happened, it doesn't prove that. Really say, look, this is what's happening. This is how what she's doing is actually consistent, exactly consistent with somebody who just acted in self-defense. Because I believe it is. Because I believe that, she's a woman, again, who's been through tremendous trauma. Okay. Now, what I don't understand is why they didn't bring a psychologist or someone in who could help better explain what she was doing and how she was acting and how she was reacting and help the jury understand that. But again, I don't know. I don't know. I'm sure there was a limited amount of resources. Maybe the judge wouldn't allow it. I don't know. I did not go digging into the case files. Like Florida lets you do that. Perhaps it's something I will do post-trial to really try to understand why the defense did what they did. Because now I'm interested. I'm interested in how this can happen in a case like this, where to me, this was a case that very much should have been a self-defense case. Now, Daisy's own testimony. My opinion, her testimony, I felt like her testimony was credible. I felt like she didn't come across as a sweet woman. I did not feel like that. I felt like she kind of had a gruff tone to her. Not all jurors are going to like that. Clearly, this juror did not like her. But she testifies that night, and we're going to watch. This is where we are going to watch some testimony here. She states basically that she testifies about the pistol whipping incident, that Pedro was high on cocaine, that he was refusing to leave her property, that she feared for herself and her children. And at the moment that she fired that gun, she didn't believe she had a choice. He's running back towards the house, as her attorney explains in closing arguments. To him, he's been told to leave. She's afraid he's going to barricade himself in there with the kids. He's high on cocaine. He's already shown 5 days before that he was willing to get violent with her. And she doesn't know what he's going to do. She knows that he is out of control. And she fires the weapon. But here's the important part. She didn't fire the weapon into his back. She didn't shoot him in the head. She didn't even shoot him in the arm. She shot him in the leg. In fact, what I would have done if a use of force expert would say, that's exactly where the police would be told to shoot in that instance. You don't shoot in a fatal place. The fact that it was fatal was actually a coincidence. And if you look at the medical examiner testimony, the way the bullet zigged and it zagged and it went through left and it went through right and it jumped through the arm, it was a magic bullet. Like remember in the Kennedy assassination, you have the magic bullet theory. We had a magic bullet here where it went through two legs, one bullet, did a bunch of damage. That's not a depraved mind. That's a woman who's firing. Now, maybe you get to manslaughter. Maybe you say, well, she shouldn't have done that. That was reckless. She shouldn't have fired in the direction she did. She should have known it could have caused death. And to me, textbook, okay, jury wants to view it that way and say maybe she shouldn't have done it at that point. She shouldn't have fired. I don't believe she fired to kill. If she's firing to kill, she's firing to hit him. It's insane. And then after the fact, she clearly doesn't think that he's that hurt. And, to sit here and get to a depraved mind, it's insane. Now we're going to watch a little bit of Daisy's testimony here. Let me get it queued. And we're going to go to, I've got to get it queued up to the correct part that I want to see as she describes. Let's see here. All right. So here we go. So here it is. And let's share this. And here we go. And then I'm going to put this up. And there it is. All right. Now, I'm going to turn my volume off while we listen to this.
Immediately before you pulled the trigger, he was going towards your door, and he was going to barricade himself inside the home, as far as you know, right?
He was.
All right. As soon as you fired that shot, did he abandon that intention and run off in a different direction?
He changed course, yes.
Okay, and he took off, right?
He began to run in a different direction, yes.
As he was running away after you fired the shot, did he appear injured? Did he appear like he was shot or hurt?
No, not at all. I didn't. That's why I didn't think he was hit at all.
Okay. Did he say anything after you shot, like, ow, or you shot me, or anything like that?
I heard, it was very faintly, but it was like, ah. So as a couple seconds began to pass by, now I'm a little scared. Did he get hit? I don't know. That's where I began to walk towards the front of the house.
Okay, what did you do with the gun at that point?
I still had it in my hand.
Okay, at some point, did you put it somewhere?
After I circled around the house entirely, I threw it inside of the tree right in front of my door.
Right in front of your front door?
Yes.
Okay. So you hid it somewhere where you would have access to it?
Yes.
Okay. All right. At some point, do you find Pedro?
At some point I did after I heard the wailing, yes.
Okay, so he was wailing, and that's how you were able to locate where he was? Is that right?
Yes.
All right, so you go to him, and what do you see and what do you do?
I see him laying there as I get out of the car, and I run up to him, and I begin to ask him, where is it at? I begin to ask him, where is it at? He couldn't tell me. He was disoriented. From there, I start to look for where it is that he was hit. I start to look for the phone. When
you say the phone, your phone?
Yes.
Because at this point, you still don't have your phone.
Yes.
All right. So before we get back to Pedro, at some point, did you find your phone?
I found the phone. It was roughly about 2 feet away from his body.
It was laying next to his body?
It was laying next to his body, like maybe he had it in his hand or he was trying to use it, but
Okay.
he collapsed.
And did you call anybody when you found the phone?
I called 911.
All right. At some point, did you try to render aid to him in some way?
At that point, I was just on autopilot. I began stripping his shirt off, ripping it off, lifting up his leg, tying a tourniquet around his leg. And then I even tried as much as to lift him up, but one of his legs, he couldn't stand on it at all. He couldn't move.
Was that the leg that was shot, or was it the other leg?
It was the other leg.
It was the other leg.
Yes.
So the other leg. So what? He's got a bullet hole in one leg, but the other leg, that's the one that he couldn't move.
Yes.
Did you know why he couldn't move it?
No, and when I would ask him what happened as far as to the leg, he couldn't tell me. He couldn't, nothing at all.
Okay. All right, so we saw the footage earlier in the trial when the police get there and what happened after that. Now we know that you didn't tell them. You weren't completely candid with them at first with the police, right?
Yes.
Okay. Can you explain to us why you didn't just tell them?
All right, so let's just stop for a moment here before we get into this next section, which is important for her to talk about what her perspective was when she was talking to the police. But what I don't know what this jury was thinking when they're hearing this, but I'm seeing a scenario where like everything lines up that this is a woman who is telling, I think, a truthful story. She shot, okay, not to kill, but she shoots for him to get away. She doesn't shoot 7 times. She doesn't unload a whole clip one time. And she accomplishes what she's wanting to do, which is to get him away. And then she hears him wailing down the street. He's wailing. He's upset. She knows, oh, wow, something's wrong. So she goes to search for him. She gets in the car. She goes and looks for him. And she finds him. I mean, to me, everything just lines up. It makes sense. And it makes sense that she didn't at first understand the severity of this injury. She wasn't intending to kill him. Okay? This is a scenario that traveled out of our hands. So how we get to second degree, again, the jury would have wanted to convict her of manslaughter or even involuntary manslaughter for reckless act of firing a gun. I understand that. In the defense, if you go back to the defense's closing argument, they really argued for like self-defense. They weren't even asking the jury for something like that. But to me, I don't understand how we're getting here. We have a woman who's lying, who's traumatized, who's going through trauma, and it just makes no sense. This makes no sense as to how they're charging this case. And to me, this testimony was compelling testimony that I felt was genuine testimony that, yes, I understand she lied to the police initially. I understand she didn't tell the police what was happening. She was afraid. If there's ever a moment that should be taught in law school, that should be taught to every American, why you request an attorney. If she had requested an attorney who would have explained, she could have explained her story to, who she would have had protection for when she explains that story to, that attorney would have been able to guide her with how to present this to the police in a way that would have absolutely made sure that she was going forward and doing this in a collective way. Look, there should be no waiver of an attorney. The biggest hole in the legal, and my dad and I used to debate this, the waiver of an attorney is ridiculous. When you talk to the police, you should be required to have an attorney present. There should be an on-call public defender at all times, because obviously nobody can make a hiring decision from a police interrogation booth. But if the police want to interrogate someone, they should either give them adequate time to hire an attorney, which is unlikely if a crime just occurred, or they should have an on-call public defender come down, consult with the individual, be retained on the state's dime for the purposes of that interrogation, and talk to the defendant, explain what's going on, talk to the attorney, and be bound by attorney-client privilege, and then help guide that person through if they want to talk. The only decision should be is, do you want to talk to me or not? Or do you want to have the chance to hire private counsel or not? But if you choose to talk to us tonight, then we're going to get an attorney down with you. And that attorney is going to talk to you about everything first and make sure you fully understand your rights. That's how the system is supposed to work. And the fact that we have seminars and gaming of the system and police officers that are trained to trick people and lie to people, and we're okay with that. I mean, the police are in the business, of course, remember, of their business is to establish, it's not, many people, they're investigating crimes. Yet, while they are, but the result of that is that they're going to take away a citizen's rights and lock them up, and they become property of the state. So before someone could do something that could cause that issue, they should be able to have counsel present, and it should be required that they're present at all times, regardless of how heinous their crime is. The rights, our constitutional rights, are so very important. It should be standard that we have someone there, because we don't understand them. We don't understand the law. The average everyday person doesn't understand the law. If we had this requirement that an attorney is present at all times in every interaction with law enforcement, that is the moment you become in a custodial situation, or it's going to be used against you. That should be the standard litmus test. There's no tricks. There's no nothing. There's no getting around Miranda. There's no waiving your rights. Why would anyone waive their rights and end up in this situation? Why would anyone? Common sense would tell you that no citizen should ever waive their rights. But we set up a system that by default and by standard tricks people. Anyways, I got off my high horse on this. But this is a major issue that needs to be filled. And Florida is a state that's at war with the constitutional rights of the average everyday citizen. And if it's all over their system, from the only 8 votes needed for the death penalty, to 6-man juries, to numerous other things that have come up. Hell, Florida doesn't even make it a requirement that a parent be present for juveniles questioning. They've eroded the right to remain silent so far in Florida, it's ridiculous. But anyways, it's a story for another day. Let's keep watching.
Everything from the get-go, and why it took a little while before you could get to that.
They would have taken my kids.
Why do you say they would have taken your kids?
He wasn't supposed to be around. He wasn't supposed to be around the house at all. His mom was supposed to supervise them. He wasn't allowed to be there at all.
So you were afraid that because you were, if I'm correct, you're saying that you were concerned that because you were giving Pedro more visits than he was entitled to under that order, that they might penalize you. They might penalize you and possibly take away your kids, and that was a concern for you, correct?
Yeah.
All right. At some point you were handcuffed while you were still at your house or in the area of your house, correct?
Yes.
You tell me what happened. When did that happen, or how did that happen?
Well, I kept asking the officers the entire night. I was asking the officers the entire night whether they had resuscitated him or not. So I was pretty hysterical because they wouldn't tell me. They said I had to wait for the investigator to arrive for me to know anything as far as what's going on with him. In the process, I was calling hospitals to see where he was at, admitted. Finally, the investigator arrived, and as I walked up to him, I asked,
objection, hearsay,
if he was still alive, and immediately he told me no. I threw myself to the floor. I started to scream. I started crying. And
okay, so that's when you get confirmation that Pedro's dead.
yes,
All right, you said you threw yourself to the floor, you were emotional.
yeah.
What happens after that?
Pedro opens the door. I guess he woke up.
Pedro Jr.
Yeah, he opened the door. He was locked in the room, so he must have came out. He knew how to pick the lock. It's funny. He came out the room and he opened the door, and the detective pushed him back in, and he arrested me, and he told him, don't come back outside.
Objection, hearsay.
Okay. If you recall, how long?
All right, so we're not going to listen to the whole piece of testimony here, but look, you have to remember, like these detectives, I think the relevancy of listening to this portion of what they did here. This is a woman who's hysterical, who's upset. To me, if you're looking at like the way these police officers acted in this instance, I don't understand it. Right? They have a woman who clearly is acting shocked, upset, can't understand how this is happening. There's a history of violence, and yet their perspective is to arrest her, take her down, interrogate her for 14 hours, treat her like a criminal, not thoroughly investigate this situation, not wait for the medical examiner's report to come back and understand it all, but they arrest her hours later after a 14-hour interrogation. Anyways, look, it's that mindset. It's that approach. It's how she got to where she was at in this case. And of course, her decision to not have an attorney present when she's talking to these police officers. Anyways, very, very disturbed by the way this whole case was handled. And then we haven't even got into the missing evidence and the fact that the police disposed of potentially exculpatory evidence that would have demonstrated and supported her case. Anyways, hold on. We're getting ahead of ourselves. So let me pull our document back up so we can continue this journey. We're already going to 52 minutes, so we're already getting dangerously close to what I didn't want to have happen, which is this to be an extremely long situation. So anyways, you heard, her testimony comes in. And remember, when the defendant testifies, yes, it's a judgment of credibility, but also the things that the jury chooses to believe is now evidence. She now put evidence forth that the state now must disprove beyond a reasonable doubt. Okay. So it's not light. You don't take that lightly. Now let's talk about the state's case and the burden that they couldn't meet, because we're going to get into it, right? The burden they couldn't meet. Their requirement in this case was to prove that she didn't act in self-defense. Once the judge activated self-defense and said that the defense met the very low threshold of showing self-defense as a possibility, now that burden's in full effect. So remember, the state doesn't just have to prove that their version is more likely. They don't just have to create doubt about Daisy's story that she told on that stand. And I don't know how anyone could sit up there and say that you doubt that story doesn't at least raise some doubt to the state's case in the way they said this thing happened. They got to prove beyond a reasonable doubt that she did not reasonably believe deadly force was necessary. So we asked the questions. Can they prove the pistol whipping didn't happen? No, because PJ testified to it. Can they prove Pedro wasn't on cocaine that night? No, the tox report confirms it. Can they prove Pedro wasn't being aggressive? No, Josephine Perez witnessed it. Can they prove Daisy's fear wasn't reasonable? No. Given Pedro's history, her fear was completely reasonable. The state's burden was to eliminate reasonable doubt about self-defense, and they have not done that. They cannot do that. And the evidence didn't permit them to do that. And this is why Attorney Tomas should come up with those 4 questions. Can they do that? If there's doubt about any of those questions, if those exist, that's reasonable doubt. That is reasonable doubt. Then we get into the evidence they lost. Critical surveillance evidence from the neighbor's DVR was lost. And I covered this immensely in a couple of videos. And this wasn't just any evidence. This was footage that could have shown Pedro's behavior in the hours and days before the shooting, because this was a DVR. There was 30 days worth of evidence lost on that DVR. They could have seen the pistol whipping incident. They could have seen and confirmed what happened, how he ran down, what they saw, what was going on at the moment of the shooting, and exactly what was being said, done, and exchanged. But what did that footage contain? Well, we're never going to know because the state lost it. And when the state loses evidence that could have helped either side, the law would require that we review that in the light most favorable to the defendant, because the state had a duty to preserve that evidence, and they failed. And that failure creates reasonable doubt by itself. And the jury was instructed on that. And that alone, the defendant was deprived to show that video. And the fact that the state lost it, it was in police custody, and if that was lost, the jury should have been viewing that in the light most favorable to the defendant, and that should have been a reasonable doubt in and of itself. But this jury, we know, absolutely didn't consider that. Why? Because they weren't even back there long enough to consider any of this. So let's look at who they couldn't discredit. We had the 11-year-old son. Prosecutor had to discredit PJ's testimony about the pistol whipping. They tried to suggest he was coached by his grandmother, which I thought was despicable. People should be outraged by that, but they're not. This is an 11-year-old boy who's losing his mother. This young man is not going to lie on behalf of his mother. Kids don't do that. He's not going to lie. He's talking about what he saw, what he heard, what his truth was. But he testified clearly that he remembered the events himself, and that his grandmother, while his grandmother helped him with the timelines, didn't tell him what to say. And more importantly, why would he have lied to help convict his mother of killing his father? What possible motive would he have? And the obvious answer is he wouldn't lie. If he thought his mother killed his father and that his father was an innocent person in this and an innocent person in that incident, he wouldn't have had any problem saying, hey, mom did that. Why would he want his mom around if he thought she was a dangerous person? He testified about what he saw because what he saw was the truth. And then we have Daisy's mom, Josefina Perez. She testifies about witnessing Pedro's aggressive behavior on the night of the shooting. And the state suggests to her, you saw how bad they treated her. And when prosecutors treat witnesses bad like that, when they treat people with disrespect, it's because they don't like what they have to say. It's because they are afraid of them. And because they have nowhere else to go, because they don't like the truth that they're bringing to court. And this jury let them get away with it. She testified to what she witnessed. She came in as a concerned mother because of the pistol whipping incident. Something we know happened because PJ tells us it happened. There's hospital records that tell us it happened. Then we have the forensic evidence that supports self-defense. The crime scene evidence. And again, I have a link here. If you have this report, pull it up. You can go right to the video where this crime scene tech testifies. And she testifies that shows that the blood trail was extending from the shooting location back towards Daisy's front door, corroborating the theory from the defense that Pedro was at or near Daisy's door when the shot happened, supporting her claim that he was trying to enter her home. She was defending herself and her children. And then she fires the shot and he retreats. No weapons found on Pedro. The state the state in their closing, they made much of the fact that there was no weapon found on Pedro's body. But Florida's self-defense law, and this is the straw man argument that the state's using to get to where they want to get to in this case. It doesn't require you to be armed. The question is whether or not Daisy reasonably believed that deadly force was necessary. And we're going to go over, and here's what supports it. Go back and watch this trial and all of these things. He has used a gun against her 5 days earlier. He's highly intoxicated. He's exhibiting aggressive behavior and erratic behavior. He's refusing to leave her property. Her children are inside the home. He's running towards that home where the kids are. There's a protective order in place. She's told him to leave. Her belief that deadly force was necessary and reasonable, regardless of whether Pedro had a weapon or not at that exact moment, did not matter. It mattered what her mindset said. And the fact that she'd been pistol whipped by this man had told her he didn't care if he died, that this man was high on cocaine, alcohol, and marijuana, and that he was in an enraged state. If he got a hold of her, if he got in the house, he was going to try to manufacture the situation, and she knew what was coming. She didn't have to guess. She knew what was coming because it had happened 5 days before, and he put her in the hospital, and she didn't have to wait on that. She didn't have to wait to be put back in the hospital. And then there's the DNA evidence that they presented. They testify about this 28.78 septillion match and testifies that this places Daisy's DNA on the firearm. Well, they treat this as proof of something, but it proves nothing. She handled the firearm. She admitted it. Why was that even brought in? That question was never there on whether or not she handled the firearm. So it makes no sense. No sense at all. So now the final thing. Let's talk about it. Reasonable doubt, right? It exists throughout this case. So let's talk about what is reasonable doubt. So the judge. Now again, this was prepared. I was preparing this and prepared to present this today because I thought it was going to be a somewhat extended deliberation. I was going to get home, and this is what I was going to be doing now while we were waiting for deliberations. What is reasonable doubt? The judge is going to instruct, or they instructed the jury, that reasonable doubt is not a mere possible doubt. It's not a speculative doubt. It's not a doubt based on sympathy or prejudice, but it is a doubt based on reason and common sense. Now, we've gone through all of this. You go back through it. You've watched this trial with me. I'm expecting that. We watched some of her testimony. If after considering all the evidence, you have a reasonable doubt about whether Daisy Link acted in a lawful self-defense, you must acquit her. This is what the judge is going to tell the jury. You cannot convict based on probably or more likely than not, or I think so. The state's got to eliminate all doubt. So let's go over and we're going to go through where all the reasonable doubt is in this case. And this is what the defense should have done, in my opinion, and had some sort of a demonstration or some sort of thing that says, look, this is the reasonable doubts. State's got to overcome this. When they get back up and stand back up to you, these are the questions they need to talk about. They need to answer these questions. And you know what? They won't touch them because they can't. Because it doesn't fit their story. They're going to talk to you about other stuff. They're going to talk to you about things that inflame you. They're going to try to tell you a story that they're going to talk about everything but these things. They're going to talk about Pedro's violent history. Are they talking about that? Can the state prove beyond a reasonable doubt that Daisy's fear was unreasonable? No. A man who pistol whipped her with a gun 5 days earlier returns to her home high on cocaine. Any reasonable person's going to fear for their life. That's a reasonable doubt right there. The cocaine evidence creates reasonable doubt. Can the state prove beyond a reasonable doubt that Pedro wasn't dangerously aggressive due to his cocaine intoxication? Absolutely not. But the tox report and the friend's testimony established that he was. They got to prove he wasn't. Have they done that? Absolutely not. The lost evidence. Okay. Can the state prove that what was on that surveillance footage they lost? No. Can they prove it was footage that wasn't exculpatory? No. There's reasonable doubt that what they would have seen on there would have supported Daisy's claims about exactly what led up to the shooting. And they have to give that to the defense because the presumption of innocence requires it. That's reasonable doubt. The witness testimonies create reasonable doubt. PJ testified that Pedro attacked Daisy with a gun. Josephina testifies that Pedro was aggressive. Can the state prove beyond a reasonable doubt that they are lying? That they haven't even tried. They couldn't try. The best they could do was say, oh, they're out there watching Law and Crime. Discredit them and discredit their truth. They brought not one scintilla of evidence in to show that this wasn't true, that he wasn't aggressive. The ring audio interpretation creates doubt. The detective admits that he could only hear the word die from the allegedly clear audio. The defense presented an interpretation showing that Pedro said, I want to die. Can the state prove beyond a reasonable doubt which interpretation is correct? No. And because the audio quality didn't permit that certainty. And you know what the law says? When there's a tie, when you can't determine it, you presume innocence. You take the innocent explanation. Boom, that's reasonable doubt. Daisy's behavior creates reasonable doubt about premeditation. First responder testified that Daisy was rendering aid, waving down police, screaming frantically about her being in a depraved state of mind or wanting to have him dead. Can state prove beyond a reasonable doubt it was all an act? No, they can't. The more logical explanation is she's in a genuine shock and trauma, as I explained. She's just had an altercation with a man who pistol whipped her and put her in the hospital. She's in this cycle. The cycle that pulls him back in. And she shoots. She doesn't shoot him in the head. She doesn't shoot him in the back. She doesn't shoot him in the arm. She shoots him towards his legs. She shoots towards the ground. It ricochets up. Is she some expert marksman? Did the state prove she was an expert marksman who could hit an artery in the leg? Like they were trying to say, oh, yeah, I think I hit an major artery. Where's the proof she's an expert artery or expert marksman? Now, what I expected was the defense to say these things and to put these things up. And while I thought he did an okay job explaining certain things, I didn't feel the passion from him. I didn't feel him sitting up there going, does this make sense? Because to believe the state's case, she has to have this amazing ability. He should have been asking the police officers that, you have firearm training, or, you shoot someone in the arm. How would you know to do that? She's shooting in the dead of the night, 3 a.m., scared to death. Yet she knows how to hit an artery as he's running away from her distance away. Come on. That's reasonable doubt in and of itself. It's reasonable doubt as to whether or not this was self-defense and what her intent was when she fired that weapon. So the next part we got to understand when we're talking about this is the presumption of innocence, right? And I've touched on it here. So what is the presumption of innocence? Why does the standard exist? My dad taught me, founders of this country, understood something fundamental, that it's better, and my dad used to say this, and he used to use this in his closing arguments, it's better that 10 guilty people go free than one innocent person be convicted. That's why they created the highest burden of proof known in the law, proof beyond a reasonable doubt. So I always find it funny that when you have these real constitutionalists believe, oh, I'm high on law and order. Oh, lock everybody up. Throw them at the bottom of the jail. That's not what our founding fathers believed. That's not what those guys who created the Constitution believed. They did not believe that we lock people up and that we say we'd rather convict an innocent man than a guilty one. No. They say they'd rather 10 guilty people go free. That is the principle and the bedrock that our legal system is built upon. And that is how it should be looked upon. And that's why the standard of the presumption of innocence exists. And it exists because of the state's enormous power. I was actually talking to someone at my YouTube event I went to. I was invited down to headquarters earlier this week, and I had to do some traveling. I mentioned that was where I was traveling to. I was talking with someone about this principle down there. And it's because of the enormous power the state has. They have investigators, forensic labs, unlimited resources. Defendant Hadley has their attorney and their constitutional protections that are built into the system. They don't have the resources. They don't get to go hire someone at $300 an hour. So I always find it funny when the state questions somebody and says somebody actually has resources. Nothing pisses off a prosecutor more than when they can hire an expert. But yet the state can hire every expert from here to mankind, and they employ them, and they pay them $80,000, $90,000, $100,000 a year. And they pay for them to be in a lab and process all these cases and generate all these reports, and they pay them to come to court, and they have every resource that they need. Private investigators, DNA labs, they can do it all. But you or I, we have to fund that ourselves. If the state comes and says, we have a report, and you go, I know I wasn't there. Well, you've got to have the resources. You better have thousands of dollars in your bank account. You're going to have to go and you have to figure out how to do it. And if you get locked up and your bond is denied, you're going to have to figure out how to do it without a job. You have to do it in the state is going to provide you limited things. And we have people out here who say, oh, well, give them nothing. They're accused of a crime. That's ridiculous. We can't have that. But the presumption of innocence is what is supposed to even the playing field. It's not just a nice phrase. It's a command. Daisy Link is presumed innocent. The state has to overcome that presumption with proof beyond a reasonable doubt. They've not done so in this case. I've shown you why. I've shown you in this report. Go back and read it and go back and watch it. My father, as I've told you, you wonder who that guy is. I had people questioning it. What's 1948 to 2024 mean? That means that is my dad. That's when he was born and when he died. That's the day that this earth lost one of the greatest legal minds of all time that you never hear about unless I talk about him. He's from the West Virginia area. And people in West Virginia would know about him. You go to my town and talk about him. And I've had people come in who wanted to do documentaries and wanted to do podcasts on him. And they came in and they said, oh my God, they walked into town. I said, go walk downtown and ask them. They did. They said, oh, wow, these stories. Yeah, it's a pretty incredible story. But he was a criminal defense attorney. He went to prison for protecting attorney-client privilege. He was prosecuted for teaching people their rights right from a coffee shop, because that's what he did. That is what he ended up doing. When the system threw him out, when the system got mad at his successes, they destroyed him because he insisted on the principle every single time the state had to prove their case. He challenged them. He challenged people. He challenged the times when they weren't upholding people's due process rights, and he made the state prove their case It's not a technicality. People, prosecutors and everyone, a lot of people forget that when a prosecutor or a police officer says, he got off on a technicality. No, he got off on a mistake you made. He got off on you not following the rules. And the defense attorney had the fortitude and the courage to stand up, go to court, and raise that issue, even though it wasn't popular. My dad did that. My dad got a guy off once because they lost the ballistics report, which was the only evidence that convicted that individual. My dad went and raised that issue. Many lawyers, it was standard practice to waive a preliminary hearing and let him get indicted. He didn't do that. He said, let's have the preliminary hearing. He brought him into court, and they found out that they lost all the evidence, and his client walked. And people could blame my dad and say, how could you let him get off? Well, no. The question is, how could a police officer be so irresponsible? How could a sheriff be so irresponsible that they lost key evidence? Don't come at the attorney. Go at them. Fix the system. Educate the system. Educate those. These police officers show up at the scene and treat her the way that they treated her and proceed to advance this case in the way that they did. They lose important key exculpatory evidence, and nobody seems to care. She didn't have to prove she acted in self-defense. She just had to present evidence of self-defense, which she did through multiple evidence and through her own testimony. Once she does that, the burden shifted. She met the burden that she needed to have. So what can we conclude from this case? And this is our conclusion. This is my conclusion from this report. The case is tragic. A man died. 2 children lost their dad. A family is destroyed. Of course, this verdict doesn't undo that. Now, the jury's already ruled. We respect that verdict because we have to. But the question is not whether, the question before this jury wasn't whether or not this was a tragic situation, because it was. It was unfortunate. It was one that we would like to have seen the system intercede before 2 people had to go do this and before 2 people clashed together. The system failed them, obviously. The makeup of it, the protective orders. It didn't do what it was supposed to do. The question is whether or not, the question that was before this jury, and the jury answered it, was whether the state met its burden beyond a reasonable doubt that Daisy Link killed Pedro Jimenez, rather than her defending herself from a man who had attacked her with a gun 5 days earlier, returned high on cocaine, exhibiting threatening behavior, refusing to leave, and she saw it heading down that road again. The evidence in this case showed that Pedro had a documented history of violence. He pistol whipped her with a gun. He was severely intoxicated. Multiple witnesses corroborated his aggressive behavior. Daisy feared for her life and her children's safety. It was reasonable, in my opinion. How could you not say it wasn't? You have a man high on cocaine, 0.108 alcohol level, marijuana in his system, a perfect storm of substances. He's angry. He's crazed. He's screaming. He doesn't care about dying. He's running towards her house to go inside there to figure out how he can do anything he can to get to her. What is he willing to do? How many times have we seen domestic incidents like this turn into something where children are killed? But apparently down in Florida, let him go inside. She fires a shot that ricochets and hits his leg, goes through 2 legs, doesn't hit him. She doesn't shoot him in the head. She doesn't unload a clip on him. She fires 1 shot. She accomplishes what she wanted to. He gets hit. He runs away. She later hears that he's hurt in the alleyway, and it starts to set in of exactly what happened. She goes down. She calls 911. Now, she says on the jail call, man, I wish I'd have cut him up. Yeah, I guess she probably does now because the system turned on her. Her behavior, in my opinion, is consistent with shock and trauma. The critical evidence that could have exonerated her is lost by the state. And the state decides to use ambiguous evidence, terrible audio, claiming that it favors the prosecution without acknowledging any alternatives or that there's any other alternative options that exist and how they would interpret it. It's crazy. It really is. They claim she made some statement about, I think I hit a artery, and well, look at how she was acting. She was calm. Are you kidding me? This is the evidence that we have to refute self-defense against a man who just pistol whipped this woman 5 days before, who's enraged. Now she's finally confirmed that he's cheating on her. He's ready to go, man. He's ready to take her out. Under Florida law, and this is the final thing we'll leave here, once self-defense evidence is raised, the state had to prove beyond a reasonable doubt that the defendant did not act in lawful self-defense. And that's the burden. That's the standard. And in my opinion, they didn't meet it here. If you have a reasonable doubt and the evidence creates multiple sources of reasonable doubt in this case, as I've laid out, you got to acquit. Justice does not mean punishing someone because a death occurred. That's not justice. Okay? Justice means applying the law fairly, honoring the burden of proof, and acquitting when the state fails to meet that burden, having the courage to do so when the state doesn't meet that burden. And reasonable doubt exists in this case. And in my opinion, the only just verdict in this case is not guilty. That is the only verdict that should have been rendered in this case. And again, that's my analysis of this case. I will say I respect the jury's verdict. I respect the jury's verdict because we have to, right? And it's very important that the jury's verdict gets respected. And we recognize that. We recognize the fact that these are private citizens who are not lawyers, who don't have any special training with the law. They were brought into a courtroom. They gave up they had their lives interrupted, and they did the best they could with the evidence. But I believe that somewhere along the way, it's unexplainable in that. But listen, 61% of long crimes chat had were voting guilty. Okay, I think I had I don't know. I think the final poll was like at 40%. So we had a lot more people that saw it differently, probably because they were, following my coverage and seeing the coverage that I gave of this case. And I don't find, I have no problem saying when the state meets its burden, and they do many, many times, and that's the way it should be. That's a system that's working. The system is not working, and defense attorneys are not present, as my dad would explain. They're not there to, get you off. They're there to ensure that you're getting a fair process and that your rights are respected and that your right to due process is respected, that the burden of proof is respected. And they're there to ensure that if a case goes to trial, if it's not been agreed upon that the state holds all the cards and a plea bargain's worked out, but if it goes to trial is not about a search for truth. That's the most annoying thing I hear. And of course, it comes from like court TV and in movies and things. It's not a search for truth. It's a verification of the truth. It's a evaluation of the truth. Prosecutors like to frame it that way because they don't want the focus on them. They want the focus on the defendant. But the reality is the defendant is presumed innocent, and you are to look as a juror. You are to determine, has the state met its burden, and does the evidence prove beyond a reasonable doubt that each and every element of the crime being charged was met? And if it is, and there's no doubt, and you unflinchingly say, okay, and look, like I said, a majority of cases should be guilty. If we've got police that are doing their job and respecting the law and following the investigative principles that are laid out and following the constitutional principles, it should be guilty most of the time. And that's why we recently covered a case here where everyone was like, what's the defense? And the defense was essentially, it was the Isabel case. And it was like, what's the defense here? And literally he had a really good attorney, a really highly respected Tennessee attorney. And it basically all he did was question the case. He raised doubt. He made the state prove their case. And sometimes that is the defense. And that is a good defense. And someone said, well, he lost the case. He didn't lose the case. There isn't losing or winning a case. The only lost case is when something isn't done right. Is when a right isn't respected or an issue isn't challenged. That's a loss. A loss is not in guilty or not guilty. In an evaluation of a defense attorney or a prosecutor's relevance or how good they are is in how they follow the law and how they present the case. A good prosecutor puts on all the evidence that he has. A good prosecutor dismisses a case that he knows is no longer meeting the standards that he needs to have, that is no longer meeting the standard of proof beyond a reasonable doubt. If there's a problem with the case, dismiss the case. Step up and dismiss it. You know. And that is the signs of a good prosecutor. In my opinion, the criminal justice system has been turned on its head by how we're being taught to look at it. And it's being done that way because they're attacking the presumption of innocence. They want to get rid of it. I remember when I started this channel very early on, there was a really bad case, and it is a horrendous case. It was a father who killed his 4 sons, and Julie Grant on Court TV said, "Oh, there should be certain cases that we suspend the presumption of innocence and we suspend constitutional." And I said, "Absolutely not. That's insanity." It was like, this guy he deserves it. No, he did, and they even ended up throwing out the police in that case didn't follow proper constitutional protocols, and they got the statement thrown out. But it was a case that you didn't need the confession, but they got it thrown out, and that was good because the attorneys had to learn that guess what? You don't get to go do whatever you want just because of the horrible nature of the crime. You've got to follow the law, whether it's the worst defendant you've ever investigated or it's something that's a small, minimal crime. And if you don't do that, we got to know that there are attorneys and defense attorneys who are willing to go in and hold those accountable. Because if they're do it to them, they'll do it to you. And the system will get things wrong occasionally. And it's more apt to get things wrong when we don't follow the constitutional protections that are built into the system specifically to avoid those situations. And one of those is, my opinion is, and I know this will not be popular out there, but one is that it should absolutely be codified and brought into law that anytime a private citizen has contact with law enforcement for investigative purposes, that it must be required before it can be used against them. Not that you have a right, not that you're asked. I mean, that's ridiculous, right? I mean, no citizen who, especially one, if you ask her, "Hey, do you wish you had an attorney with you then?" Of course she did. It should just be the law. A on-call public defender will come down, meet you at the police station, discuss your case with you. It can't be held against you. Attorney-client privilege attaches. You discuss it with him, and he can advise you on what you should or shouldn't do. And if you decide to sit down with law enforcement, they're going to sit there to be with you, to go in and out and pull in and out of the room and say, "Okay, hey, look, let me explain this to you. Let me do this. Let me make sure it's fair." And that is the only way to guarantee fairness. And that is the only way to guarantee that we have a system that works. Putting common sense principles like that in, removing the trickery, removing the ability to try to trick someone into waiving a right, removing the idea that people who don't know what they're doing should sit down with trained police officers and try to have a conversation with them about a moment in their life that's actually at their lowest moment. Potentially they're traumatized, like this lady was. She stuck with them for 14 hours. The only sleep she got was in an interrogation room. Then the police are out there losing key exculpatory evidence. And you know what? They got held accountable for none of it, and they got a full conviction on everything. Not a great day for the justice system. But listen, hats off to those jurors. I respect what you did in this case. I just don't agree with you. It is what it is, but we're going to go forward. And the beautiful part about it is our justice system still continues going forward because there's now an appellate system that she's going to enter who will review this entire case and review this entire record. And we'll be following that as it goes through. And maybe we'll see the retrial if she would be granted one. She may not. But of course, first we got to get through sentencing. So understand this. For second degree, which he was convicted of, the judge does have quite a bit of leeway. Now, there is a firearm aspect to it, so that comes with some minimums. And, so we'll follow this closely. That's why they ordered a PSI. The state's going to be asking for life in prison. I mean, that's what they want, I'm sure. We'll see if this judge does that. And, if they give her 25 to life in Florida, there is no parole. She'll serve 25 years before she gets a chance to get out. I don't think she should be locked up for the rest of her life in this instance. I don't think the judge that. I got the vibes from the judge in this case, and I don't think the judge liked this case. I really don't. I think the judge was troubled by some of the things going on. All right, give me a moment here. We will find out here. I want to find out exactly what the options are. So essentially, here's what's at stake. There is some leeway, but because she used a gun, normally it would be punishable by up to 30 years in prison. But once the firearm gets kicked in, Florida's firearm law, which is the 1020 life law, it imposes a strict mandatory minimum for the crimes committed with a gun. So what it does for this case, because a firearm was used and the jury found that, the judge now has to decide. The judge could impose a 25-year, she's going to face 25 years minimum. The judge can impose any sentence from between 25 years to life. If the judge goes life, there's no parole. If the judge goes 25 years, she's serving 25 years. 30 years, 40 years, 50 years. She's going to serve day for day because a firearm was used. So she's looking at a very severe sentence. And if this woman was truly defending herself, like I think she was, wow, we've done a serious disservice to this lady, especially being a victim to what she was a victim of in this case. Give me your opinion. I want to know. I want you to tell me in the comments. I'm going to run this as a live premiere this evening. I want you to tell me what you think about this case. Do you agree with me? Do you disagree with me? And I will do a follow-up on this. I may even go live with it. It may be a video, or I just return the comments, or I might even go live and give us a chance to talk about it. And you guys can come in and comment at me directly. But I want to hear from you. What do you think? I want to hear from you. Do you think it would be a good thing to have a requirement that everyone get access to an attorney anytime they come in contact with law enforcement, and anytime that contact is going to result in something being used against them? Do you think that's an unreasonable requirement? Do you think that would solve a lot of our problems and make things a little bit fairer for everyone? I think it would be. Tell me your thoughts. Anyways, until then, guys, keep watching. We're going to have other cases coming up. We've got our live premiere trial series that'll be starting very soon. We're going to be handling the A.J. Scott case out of Georgia. I'll probably do a live show on that to start it out, explain what's going on with it, how to watch it, how to enjoy it. It is a case that already happened. Some of you may already know the verdict, but we're going to watch it. We're going to premiere it. We're going to talk about it. We're going to break it down, and we're going to give it the coverage it deserves because we didn't cover it. And we're going to start doing that with some of these cases that we're unable to cover when they're going live, because unfortunately you can only cover so much and do it in a way that I believe is beneficial and benefiting to the case. So be on the lookout for that, guys. Become a Justice Watcher member now. Like I said, you get access to the Justice Watcher toolkit. You can go back in the Justice Watcher community, find links to all those toolkits once you become a member. Heck, 1 month, you can grab them all up. And it organizes your experience and lets you get access to all documents, all things. And they're in there early before sometimes they even go up. You're going to get early access to all of our podcast videos that we're putting up in our trial podcast series that we do when we're covering our featured cases. You're going to get early access to key moment videos, certain videos you're going to get key access to. And there are certain trials we will put behind the paywall as well and lock them down for members only for your enjoyment. So there's lots back there to do that. And of course, we're going to be trying to get more interactive and do members only lives, members only question and answers. They're coming. It's coming. I promise. I've been saying it, but we're going to do it. We're working on it. We want to bring this experience and connect with this community because you guys are what makes this the lifeblood. You guys are what makes this possible. And we need you. We need you to be out here. And I don't care if you agree with me or disagree with me. I want you to be engaged If you agree with me, that's great. If you disagree with me, that's great too. Let's have a conversation. Let's be respectful. Let's keep it respectful in chat. All my moderators out there, if you made it this far, I should have said it at the beginning, but I appreciate each and every one of you. And I watch and see who I can bring into the community that can be a watchdog for us and help cultivate a safe, fun, great chat. And I appreciate each and every one of you. I'm going to try to connect with you and work on creating some methods for us to get together, connect, so I can thank you personally for all the hard work you're putting in, helping us keep the chat great. So I really appreciate all of you guys. I appreciate everyone who has built this community. We're going almost 80,000 strong. And when we hit 100,000, we are going to celebrate. I promise you that. And we're probably going to do a celebration here just because, look, hitting 75 and 50, I haven't celebrated those. So we're going to do a celebration stream where we're just going to come on. I'm just going to, go live for a few hours. Maybe I'll go live all day long on a weekend day, and we're just kick it and chat. And you guys can come in and out, and I'll be here. And we're running in and out. You can see I have little ones. I have one guy who would love to come on and talk to everybody and say hi, and we'll do that. And we'll talk about some of the cases we've covered and just have some fun. But anyways, guys, if you've made it this far, I really appreciate it. I didn't want to go an hour and a half, but we did. But that's okay, because you know what? It was worth it. And remember, if you've made it this far, in the description is the report you saw on this. If you're a Justice Watcher member, it's already in your toolkit. It's under the presentation folder. You may have wondered, what is that? And you may have seen several go in and out. So maybe you grabbed some copies that were being edited and moved around and processed and getting ready, because some of the hyperlinks I did were not working and I had to do a lot of stuff. So you may watch it come in and out, but always feel free. Something pops in there, check it out, download it, get a hold of it, read it, find out the justice's take right away. That's what it's all about. You're there, you're an official Justice Watcher, and that's what the benefit of membership gets you, is early access and access to the back end before anyone else gets it. So I really appreciate all of you guys supporting the channel. I appreciate every super chat that's come through. You make this possible. Believe it or not, there's a tremendous amount of expenses that you wouldn't even think go in to making all of this possible. And, but it's not about that. This is about the legacy of my father and bringing that forward. And we're going to keep going forward and keep pulling, keep pushing, and keep growing this thing in the vision that he and I had. And you will learn more about that vision and more about him and more about the journey that we're going to be on, because it's going to be fun. It's going to be exciting, but we're going to keep watching, right? So keep watching, always watch, because remember, I'll leave you with this: justice always works better when we watch.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that walk